Tonight, the anatomy of a censure hearing. We have history playing out before our eyes in the last 24 hours, where an ad-hoc committee of parliament is, for the very first time, looking into a motion that may lead to the removal of a minister. We haven't done it before. This is the closest you come to an impeachment proceeding. And we're beginning to learn a few things. It's also maturing our democracy a bit more. And so we want to spend some time unpacking what this means. And if you followed the proceedings yesterday, you begin to learn that it's pretty challenging. It's as if Parliament is making up the rules and defining the process as it goes. And we've seen a few challenges in the process, but that is the essence of democracy. It sort of then becomes an organism, the Constitution, the laws. It's a living organism. They breathe, they develop, they grow, they mature. And that's what we're doing. It's been tested for the very first time. We'll see how this plays out. And at the end of it all, the eventual decision will be with the president. And again, that will test the Constitution. So let's unpack this a bit more. There's a significant breakdown. The committee returns on Friday when the finance minister, as you know, will have an opportunity to put up a defense. And that will also give us a bit of clarity on how this process has been carried out. But the basis of what is happening is this constitutional provision, Article 82. And there are a few things I want you to note about this clause. Parliament may, by resolution supported by votes of not less than 2/3 of all members of Parliament, pass a vote of censure on a minister of state. So you need 2/3 of all the members of Parliament. What it means is the process that you're currently witnessing at the ad hoc committee level is just the process that would lead to a plenary debate, and it's at that point that the 2/3 becomes live, and that will revolve around 184 members of Parliament as Parliament is currently constituted. If you take the view that the minority side have 137 members of Parliament, they will need 47 more people, 47 more members of the majority side to vote with them so they can reach this 184 number they need to ensure that Ken Ofori-Atta is removed as the finance minister. The key question that remains, can they get a number? This is by secret vote, by the way, and we expect that to be so. And so we expect that, it may throw up some surprises. But if you throw in the other complication that the party, the NPP, has issued a 3-line whip, in essence, through the whip system in Parliament, asking their members to abstain, not to participate, not to vote in this process. We would also explore tonight what the implication of that is, a 3-line whip. We've heard that the ultimate sanction for violating that 3-line whip could be that a party will expel you, will expel a member of Parliament. It hasn't been said in the statement that was issued, but it's implied. They will expel you. And some have argued that constitutionally, if your party expels you as a member of Parliament, if they expel you from the party, you would or should automatically lose your seat in Parliament. Does that follow necessarily? Is that why possibly this vote of censure will fail? Because some of the members of Parliament know the consequence, they're going to pay a high price for it. We'll get into that. Very interesting dynamics that we'll get into explore tonight. And then also, the constitutional provisions provide a bit more to this, that if you have this resolution, which is referred to what I just talked about, you need a 7-day period notice to be given for this motion. That has passed now. That is why it came on the floor and was moved, slightly debated. They debated the procedure a bit, and then the Speaker referred it. That notice of motion has now been signed in not less than 1/3, which is what the minority side by themselves managed to get, which forced the Speaker to hear it. Now, it will be debated within 14 days. The Speaker has given the committee 7 days to do their work, and they have just next week. So we expect that definitely next week, their report will come to the plenary, unless they go to the Speaker and ask for an extension. We don't expect that to happen. But it will come to the floor, and then the debate to be debated. It's so within the 14-day period. But whilst that is happening, the minister in question, who is Ken Ofori-Atta, has a right now to be heard on the floor. But that is the curious bit of this, right? Because the Constitution didn't talk about a committee that will hear the minister before the debate in the plenary. Because I see when you read this, my understanding of this is the debate on the floor of Parliament. A minister state in respect of whom a vote of censure is debated under clause 5. Where do you have debates? It's on the floor of Parliament, right? So you expect that he will have an opportunity to be heard. It's entitled to be heard on the floor when the debate is happening. But considering, because that's where his side will be heard, but considering that on Friday we'll hear him already before the committee, what happens when the report goes before the committee? Will he go there and repeat? Anyway, well, that's an interesting bit, right? I mean, it's pretty confusing. We'll get the legal breakdown of this today on the show on this. And then there's also the big question. For me, this is the big unknown. This is the big unknown. At the end of the door, what happens? The Constitution says the president may, unless the minister resigns his office, revoke his appointment as a minister. So may. He's not even obliged. He's not even obliged. Even Parliament goes through all this process, this noise and the debate and the voting and all the acrimony. At the end of it, it comes down to the president. He may not, right? So this is an interesting one. For me, this is the big unknown. And if it comes to that point, and the president says, well, this is me, I don't think that he should go still, in spite of what the Parliament have done. Well, the NDC says they'll impeach him. You know that's going to fail. Obviously, there's no way the majority side will side with them to impeach the president. That won't happen. They may go to the Supreme Court, and that then will become a long, drawn-out issue. The Minister of State, of course, is going to be there. But that, for me, is really where the heart of this is. So we are really in a charter territory. We're possibly going to be facing a constitutional crisis at some point if this process continues, right? We'll get to the lawyers to help us understand the standing. But here's the thing, though. The Speaker of Parliament, the reason why the Speaker set up the committee, although it's not in the Constitution, he was also using the standing order, right? Because the standing order repeats part of the Constitution, which you see here. I mean, you know, but then also adds a bit of the process, right? Because standing order 106 then says the House may consider such a motion and come to a decision or refer it to a committee. Right? So the House by themselves could have debated this and settled it. But there's a second option, which is or go to a committee or refer it to a committee on a motion made by a member, right? The Speaker chose this latter option, which is to refer it, because really, if you look at everything else that happens in Parliament, it always goes through the committees and then comes back. So the Speaker thought, well, don't change the process. Let's just do that. But the Constitution never mentioned anything about a committee, but the standing orders did. Is that a violation? Is the standing order consistent with the Constitution? And you know what happens when some regulation or some other law is inconsistent with the Constitution? That is null and void. So is this one of those issues? I'll get my lawyer friends and colleagues and panelists joining me to have a say on this. And of course, then we saw what happened yesterday. This played out. The evidence in chief was presented, and we know that the Gabi Ochodako, again, this goes to the challenges with the process. That's why we are calling this the anatomy of a censure hearing, because a lot we don't know. We are still trying to understand it. So let's unpack. Let's go into the belly of this animal, this beast called a vote of censure, because he comes up and says, listen, you haven't given me the specifics. But something very important was said by one of the co-chairs, and in fact, the two of them agreed, that the two co-chairs agreed on the fact that this is not even a quasi-judicial process. It is not a representation or something similar to what you have at the court. It is a purely political process. And so the issues of fairness, rules of natural justice are relaxed, right? And for me, I think that's a very profound point. But then again, if you think about it, impeachment is a political process far more than a judicial process, which is what is happening here. And so he asked for Ochidako asks for specifics. That's what you'd expect if you're going through a proper court of competent jurisdiction. You get the specific, then you go and prepare your defense. They said, no way. You just sit down and hear us, which indeed was what happened. And so he sat down and had them, they're not going to prepare, right? But the point was made, this is a political process, not a judicial process where you expect all the rules of natural justice to be charges, etc. All those detailed legal processes to be followed. This is NDC, MPP deciding your fate. It has nothing to do with the judge. We will talk about that. What does that mean for this process? At the end of this process, can, if they are not satisfied, go to the Supreme Court to challenge the outcome. That, again, is an open area. Your guess is as good as mine. But here are the numbers when it comes to even the majority members who are asking for Ken Ofori-Atta to go. It stands tonight at 98, right? So let's look at the anatomy of this beast called essential hearing. My guests are joining me. After the break, we'll get down to the specifics. Let's learn about this process because we are all very, very new to this. And this is one of the moments we'll be talking about for years because it is extending the frontiers of our democracy. And it's good to spend some time on this as we rewrite our constitution going forward. After the break, details. Joining me now is Professor Baffoe Jimendua. He is the former UN Senior Governance Advisor. I'm grateful that he could join us via Zoom. Also joining me tonight is Dr. Amako Ba. He is the former head of the Political Science Department at the KNUST. I'm delighted that he could also join us. Also joining me, two lawyers, so we could unpack part of the many legal issues that this has thrown up. Private legal practitioner Martin Kpewu joins us. Also, Justice Abdullahi, who's also a private legal practitioner, will also join us pretty shortly. I want to start with you, Professor Baffoe Jimendua. You've been in the democracy business for quite a while. So when you tuned in yesterday and you watch on television what was unfolding, seeing that it's, again, part of our constitution we haven't tested, that is all at play, how were you reacting to it?
Well, thanks, Evans. Frankly, I was delighted to a very large extent. Delighted in the sense that for the first time, we were witnessing a formal structure to hold public officials accountable. In other words, having the finance minister being brought before a parliamentary committee to be subjected to the test of accountability. In that respect, I was pleased. And you know, this was possible mainly because we happen to have a hung parliament at this time, where the ruling party doesn't have a majority in the House. Because I believe if that were the case, most likely this case would not have traveled this far. So on that level, I think it was a very pleasant thing. I watched it through. I also witnessed some kind of interesting developments in the protest. Hello?
Yes, I could hear you.
Oh, okay. Yes, so I was saying that also I was impressed by the fact that those who were giving evidences, they were very confident of themselves. They seemed to know what they want, and they posed their questions. And interesting, you made a point in your introductory remarks, reminding us, in fact, you were referring to the co-chairs who agreed that, in fact, this is not a judicial process. Because, you know, the counsel for the minister, when he spoke, he made demands of certain things. In other words, he wanted written evidence, so to speak, so he can prepare a rebuttal or response. And certainly, a political process, you won't have. In fact, if you recall what happened in the United States in the impeachment of Trump, you notice that Trump didn't have to be present for him to be impeached. And that is contrary to what we may witness in the British system, the parliamentary system. So I think some of the interesting challenges we are facing is a result of our hybrid political system that we have created. In other words, bringing together elements of the parliamentary and that of the presidential of the Americans to create our own system. So you can see, as you rightly said, this is new to most of us. And I am sure that at the end of this journey, things will become clearer. But more importantly, as you said, as we all seeking to reform our constitution, these will be some of the interesting aspects of the constitution that we'll have to give a very close attention to. But overall, I was very pleased with the process of this, censuring process. I liked it.
Dr. Makoban, you are the political scientist. This is a political process, not a judicial one. You agree? Please unmute for me. Hello, Dr. Makoban. I can hear you. Please unmute your Zoom for me. Okay. I'll come back to you.
Can you hear
okay.
me?
I can hear you now. Yes, sir.
Okay. When it started, I called some of the parliamentarians and told them, this is not a judicial process. This is not a court of law. So they should not allow the council to turn it into a court of law. It's a political process. They don't actually have to give evidence if they don't want to. What you do is, okay, if we make the charge that overall we see that the performance of the finance minister is not acceptable. He is not respectful. He is too arrogant, therefore he should be removed. What evidence do you want? This is opinion. So the whole process is not to judge the finance minister guilty or innocent. That's not what we are doing. We want to find the opinion of majority MPs regarding the finance minister. That's what it is. And so they didn't have to really go through all these charges. It's okay if you give even two charges, one charge is enough. At the end of the day, no matter what happens, no matter what the minister responses he gives, I can assure you, it's a done deal. They are going to remove him. Because it used to be 80 MPs. Now it's 97. It means more of the majority members are upset. Initially, the issue was that NDC has come up with some charges that they don't agree with. It was all politics. Because NDC also, even though they want to remove the minister, they're also playing politics. At the end of the day, when election time comes, they'll tell people, we are the ones who removed the minister. You see, as if the MPP didn't do anything. So they are reluctant to help the NDC say that. But I told them, it doesn't matter. This is the only way you remove the minister. You alone cannot do it. They alone cannot do it. So please, put the politics aside and stand for your country now. That's what I told them. And so I heard you say that in the end, it comes to the president. It doesn't. It comes to Parliament. They can remove him. And if the president, the Constitution is not properly written, I'm sorry. It says the president may withdraw the appointment. No, it should have been the president shall, because if the two-thirds majority censure the minister, then the president shall revoke his appointment. But he said may, as if he has a choice. I look at the situation, what it's going to do. If they vote two-thirds majority to censure the minister, and the president doesn't remove him, what do we have? We have a constitutional crisis, because the minister has effectively become a persona non grata in Parliament. He can't go there to do any business. How can the finance minister not go to Parliament? That's the problem. And so if the president does not remove him, it means he himself is not doing his work. Therefore, they should tackle him. And the same process they use to censure the finance minister can be used in the end to remove the president. Very, very simple. And he should know that, so that he doesn't get them going and get more angry. That is what they are going to do. If he challenges them, that's what they are going to do. I mean, when your own party majority members are against you, you are in trouble.
Yeah, and I'll come to that aspect of this, which is the positioning of the party issuing a three-line whip and the consequence of that and the constitutionality of that question as well and the democratic issues that that also raises. But Martin, we're on the same subject of this. So Professor Bafo Ejimendria, Dr. Amakoba all agree this is a political process, not a judicial one. So I ask you, Martin, the lawyer, where does that leave the rule of natural justice? Is it suspended?
Absolutely not, Evans. Absolutely not. So yes, though the experts in political science have, given their opinion, yes, to the extent that yes, the Constitution works within the fine lines of political science and law and all that. I think in this particular case, the Constitution is very clear that it should be given this in a fair hearing. That's why it says that there's a right to counsel. So I think that it's actually a mixed system, because I'll just look.
Okay.
Yes, you look at that one, and they don't have the kind of guarantees that our Constitution gives. That place, you even file the motion for censure, and it depends on the speaker giving you time. That's a majority. So if they don't give you time, you will have to find your own wriggle room to be able to move the motion. So if you look at that and juxtapose that with what we have in our Constitution, giving the number of people that you need to be able to cross the threshold, to be able to present the motion, the number you need to vote to be able to pass the censure and all that, I think we've been very intentional about it. So bottom line, Evans, one word is that, what does the Constitution say? Looking at what the Constitution is written, ours is different. I think we should appreciate that. Just look at the UK. Look at something. Let's look at something you see. It says, what I read, I say in December 2018, the opposition tabled a motion of censure against the then Prime Minister, that's Theresa May. The government did not make time for the motion to be debated. The government did not make time. So it was that control, the House of Commons. They didn't make time for the motion to be debated. So look at it, Evans. Some people think that we want to have this motion of censure against the Prime Minister, yet the government didn't make time for that motion to be debated. So it's when they like, and if you read, you go up there, you see that it's about discretion. So what I'm trying to push across clearly and forcefully is that what our Constitution is written is not exactly what pertains in the UK. That is very clear. If you look at what we've written here, 14 days, this number, give right to counsel, you don't find that in the UK expressly, at least not what I've researched so far. So to that extent, I wouldn't say this is largely political. No, I'll just say, look, it's constitutionally guided. So once the Constitution is coming, I think the political dimension is largely eroded. Yes, very much eroded, because there are timelines and it says right to counsel. And if I'm not running ahead of myself, that's how come I find it strange that the speaker then said they should go and the counsel should rather appear before the parliamentary committee. Evans' question is that, didn't the lawmakers know what they were writing in the Constitution when they said during the debate? Yes, though I appreciate that the speaker says debate is not only in the House, on the floor of Parliament. Question is that all the MPs are like the jurors in this particular case. They will take their decision. So why should a lawyer appear before a committee of Parliament and put across the defense? Don't forget that in communication, often they will tell you that the non-verbal communication, the body language, sometimes carries more weight than even what a person says from his mouth. Do you get it? Mm-hmm. So the thing is that the non-verbal communication will be lost in what the committee members will bring to the floor. So for me, it means that the right to representation is being nullified. Because maybe you have a lawyer who come, he will dazzle the MPs and they will see that, oh, no, listen, look, we don't intend to censure our colleague. Yes, through his demeanor, maybe he will come with so much supplication. He would try to make, crack jokes, all manner of things, the theatrics of it. Some lawyers are very good at it. By the time he's done, he would have melted all the anger, and you'll be amazed that they would say, the vote will be taken and it would not pass. But now you tell the lawyer to go do everything he can do before a committee. Who is going to carry across his non-verbal communication, the cues, the body language? How are you going to carry the body language to the rest of the House of Parliament? So I think that I support the lawyers in Parliament who disagree with the Speaker, notably among them, Mama Yariga, yes. And then you see even Muntaka, who is not a lawyer, you see he was challenging the Speaker seriously on that matter. Yes, and I think that I support. Maybe we should look at it, we should research it more. But Evans, trust me, once the lawyer doesn't get to make his case or the client's case directly to all the MPs who are going to vote, that ruling has taken a lot from the process. It's eroded the process, to virtually nothing. Because who is going to carry the lawyer's language and everything to the parliamentarians?
Yeah, Professor Bafo-Djumandua, so clearly you're seeing that the challenge, the tensions are there, as has just been explained. So you have a situation where the Constitution is clear that this is a preserve of Parliament to debate and decide the fate of the minister. The minister has a right to be heard. But, however, the Speaker, in deciding to send it to the committee, refers also to the standing orders, because the standing orders provides a second option, which is that, quote, the House may consider such a motion and come to a decision or refer it to a committee on a motion made by any member. Whatever it is, it has to be democratic. The Speaker believes that, let an 8-member committee look at this first before all of our representatives, your and my representative, debate and make a decision. Is this in keeping with the democratic tenets? Because I wonder, that question comes to mind. So when the 8 of them who are currently hearing the matter, they would write a report. Their report, and again, the other interesting thing is, for the very first time, we have a parliamentary committee that has equal numbers and co-chairs. We've never had that before. Normally at the committee level, they will either have a majority position or a consensus position. If it's a majority position, the minority guys will also write theirs in it, and they will submit both to Parliament. If it's a consensus position, then it's what the committee decides. But there you have a situation where it's 4 on each side, co-chairs with equal power. Isn't this becoming, asking the Speaker of Parliament, and Parliament itself has set this up for further conflict when it comes to debate?
Well, you see, I think this particular case, as I think you alluded to in your remarks, is really giving us some very interesting lessons, I should say maybe insights, in how we operationalize our democracy. Clearly, as I said earlier, this conflict between the parliamentary system and the presidential system is at the center of this particular dilemma. First of all, the Speaker certainly wanted to appear fair to the minister, that natural justice requires that if you are accused of something, you have the opportunity to respond. So that was fair in that respect.
Yeah, but Prof, forgive me. The question is, what is the right forum for that? You listen to what Pebu just says there. The Constitution is clear that a minister of state in respect of whom a vote of censure is debated, and I presume that debate is only happening on the floor, and that clause 3 of this article is entitled, during the debate to be heard in his defense. So yes, be fair to him, but that, ability to get behead should happen on the floor, not at the committee.
Correct. I can side with that. In fact, other instances of censure or vote of no confidence in other jurisdictions occur not in committee rooms, but on the floor. We've seen that in Britain. We saw that in the United States. But our peculiar constitution, I think, as I said earlier, the Speaker and others, by the way, because before even the matter was referred to the committee, you recall, I think, Member of Parliament, Afeki Markin or something.
Yeah, Afenyo Markin raised the yes.
Yeah, precisely. He raised the issue about fairness and justice in this matter. And I think that is what swayed the Speaker and others to believe that, look, we got to be fair to this guy, so let's push it to a committee to deal with. They could have chosen not to go for the committee. It could have been debated on the floor, as you say, and as Martin said. But in the wisdom of the Speaker, they decided, no, this, how are we going to do it? Then the second problem that you raised is the composition of the committee. 4-4, right?
Yeah.
Co-chairs. So if there's a disagreement, or how do they even reach agreement since there is equal numbers? So that in itself can pose some challenges at the end of their work when they have to submit the report. Are we going to get a unanimous report or divided report? So all these are things that are new to you and me. But for me, what is good is that we are really pushing the barriers of democracy. We are exploring. And that's exactly what democracy requires us to do. When you are in difficulty, you find a way out by simply brainstorming, testing the waters, and whatever that we find fits, you do it. In fact, there's no magic about it. So in this particular case, I think all of us, including the Speaker, we are exploring ways to manage this particular instance. So the idea of fairness and justice, I think, has been central to our democracy. And I think it wasn't easy for the Speaker to overlook that. You see, that's why I think he requested that, look, you go. And I think that decision in some ways was even, for me, it was a face-saving measure. Because on the floor, there seemed to have been some kind of interest and tension there. They didn't know how to handle this. So, to cool tempers, they say, well, you go to the committee and let's hear it. Now, the introduction of the council. I'm not a lawyer. I think I can wait for Martin and Justice to address that. But certainly, it seems to be turning the whole thing into a judicial process, which is also interesting because you don't find that in other jurisdictions. You know, on the floor of the British Parliament, you don't have councils coming to the aid of ministers when they are put on the carpet and they are being voted on whether there's confidence or not. So that, again, is an interesting development in our system. So we are all struggling to really understand what is the best way to handle a case where a minister has to be censured. So let's be patient a bit. It's going to be rough because, frankly, as I said earlier, if the majority or the ruling party were to have the numbers, I'm not sure this case will have traveled this far. Yeah. It's all because of the hung parliament that we have that we are beginning to see these kinds of intricacies in the system that we have created for us.
Interesting. I want to bring another lawyer who's joining us, Justice Abdullahi. And Justice Abdullahi, I want to throw this to you now because I haven't had that explored, but is there a case where this process that is now being triggered possibly could be inconsistent with the Constitution? And the Speaker references, it appears, there's a possible conflict there between standing order and a Constitution. I want to read to you, you know the constitutional provision on this, I don't have to state it, but in essence says that there shall be, a person against whom this is made will be debated and the person will have a right to be heard. And as we have heard, presumably that debate should happen on the floor. There's no mention of a committee whatsoever. But there's a mention of a committee in the standing orders, which the Speaker references as a way out, which he then uses to refer to the committee. The standing order references the constitutional provision, but then provides a second layer of referral to a committee. Is it possible there that we are having a standing order, which the Speaker has used to refer the committee, although the Constitution doesn't refer in the committee at all, where we are having a conflict now between the standing order and the Constitution? Do you see a conflict there at all?
Thank you, Evans. I think we have brought these difficulties onto ourselves. As Martin pointed out, indeed, the Constitution is very clear in its provisions as to how this is. Now, and when I say it is very clear, I say with all the authority in me, I, right on the same day that this event happened, made references to other provisions in the Constitution that provides for the removal of the president and other persons, and indeed the Speaker Now, if you check the triggering processes for the removal of these persons are outlined in clear terms, and there are similarities, a lot of similarities. However, the drafters of the Constitution, where a committee ought to be set up, the provisions provides clear guidelines for the setting up of the Constitution, for the setting up of set committees. For instance, the removal of the president. The Constitution provides, among other things, that the moment the 1/3 members of Parliament trigger the notice and send to the Speaker quickly has to refer same to the Chief Justice, who then sets up a committee to investigate the conduct or the alleged issue in reference to the president for the removal processes to be to commence. Now, guess what? Following from that, when the report finally comes back to Parliament, the provisions in there are that the president is allowed to be heard, first of all, he's entitled to be heard, first of all, and he's also, in addition, allowed to bring a counsel of his choice or any person of whatever expertise that the president believes is right for him. And that is because the president may be removed on the basis of ill health. So in that case, he may not necessarily bring a lawyer, but rather a medical doctor. If the president is being removed on the basis of a conduct, he may decide to bring in a pastor or a lawyer. If the president is being removed on the basis of national security issues, he may probably bring a security expert or a military man or a police officer. If he's being removed on the basis of any other thing or economic crimes, he may decide to bring an economist and a lawyer, possibly, if he wants to. If you go to the same provisions in the removal, of the Speaker, it doesn't even give any of these rooms. It only requires that 2/3 should vote in favor of the removal, and that takes, it's opposed, and then the Speaker leaves office. Now, when it comes to the minister, remember, the minister is not being removed from office, and so the provisions in respect of the minister are couched such that the minister is only allowed to be heard in Parliament. So in that case, what it means is that, first of all, the rules of natural justice has not been breached. The entitlement to a lawyer is not an option at that moment. Now, the misconstruction at Parliament was because the Speaker, or let's say the Parliament itself, was confused as to whether they were invoking the removal processes of the president or the removal processes of any other person. But what they forgot was that with respect to censorship, it's not a removal process. And so it doesn't go through the same laborious processes as the president has, because it's simply to criticize the formal criticism of the minister.
I mean, but when you say, when you say it's not a removal process, what is it? Isn't there a vote of censure to remove the minister?
Actually not. The end may be a removal, but it's simply to register the indignation of Parliament, or say the nation, in respect of that particular minister.
But you know what you just raised there actually throws up what I believe could be where we are heading, a proper constitutional crisis. So you're actually suggesting, and people have mentioned this, that
not
at the
entirely.
end of this...
Chairman, if you may allow me to finish.
Okay.
Not entirely. Because, once again, let's remember that per the authorities of Justice Abdullah and Attorney General, the Supreme Court was very clear that you cannot import anything into the Constitution and allow it to stand, particularly if it is coming from the orders of Parliament. Now, what I think happened here is the Speaker relying and using standing orders as superior to constitutional provision. Constitutional provisions are superior at every circumstance. And I expected that the Speaker would rely on the Constitution as a guide.
So you're saying that in this matter, in this particular instance, the standing order he quoted is inconsistent with the Constitution, therefore null and void.
And therefore could be a basis for this whole process to be thrown out. And we wouldn't have achieved anything if that happens, which is why relying on the Constitution should have been his primary concern, rather than an attempt to appease persons that he believes he's against or for. I think his preference at that moment conflicted the clear provisions of the Constitution. And he brought this to, onto himself, really, because when you have the two options, relying on the Constitution would not have allowed all the attacks that are going on presently and all these debates. But relying on the standing orders has the potential of bringing in a lot of worms into the discussions. And that ought not to have happened.
Yeah.
And the only reason why this happened is because I think there were a bit of psychological aspect of the whole thing, that the speaker feeling this sense of pressure from both corners. And so in an attempt to appease all sides, he decided to rely on a subsidiary.
Justice Abdullah, stay with me, because obviously, I mean, it's very obvious that I guess what is, and Professor Bafo makes a point, we are all, because this is an uncharted water we are in now, we are all beginning to learn. But I want to move to something that you've just started there. The end game. I mean, we are now trying to find a way, we're still not sure the process is going, we are making the rules as it goes. But the end game, from the minority side, they want the man removed. I want to get there now. I want to bring in Dr. Amakoba. Doc, so you go to the Constitution. The Constitution says at the end of this process, if the minister doesn't resign by himself, the president may revoke his appointment. Yes. So he has an option, right? Yes. In the matter, you say the Constitution shouldn't have said may, should have said shall, but the reality is may. So isn't this all an exercise in futility, and we're wasting everybody's time when the president really, we place this whole thing back in the hands of the minister and the president?
Well, it is in a way, but it isn't. It's because of, as the council is saying, how the speaker set it up has thrown more monkey wrench in the arena. You see, they shouldn't have set it up that way. The whole parliament becomes the committee. How do you set up a committee of equal numbers and two chairs? How do you get a result? What's the report? This is why they are fighting already. You see, if you was going to set a committee at all, you didn't have to, but if you were going to set it, it should come from those who brought the motion to refine what they want. Make sure you have evidence, whatever. You see, we have turned this into court again. Even as we are talking, I see that we turn it into court. We are not in parliament to get justice for the minister. We are not in parliament to find out guilt or innocence of the minister. We are in parliament to find out the opinion of parliament about that minister. That's what it is. And we keep talking about being fair. Being fair to what? The Constitution says that the minister shall be given the chance to defend himself during the debate. We haven't even started the debate, and the minister is sitting in parliament with his lawyer. Why? It doesn't say, Council people said that we are called the minister a lawyer. We don't. It doesn't say that. He may bring that, and being fair, the speaker may allow it. But it just says that he can defend himself. It doesn't say he's entitled to an attorney. It doesn't say that. But in most jurisdictions, it's okay. Sometimes you are shy, so if somebody is helping you, I mean, you are facing the whole parliament. And so that is okay. But let's not forget, this is not trying to prove innocence or guilt of the minister. It is trying to determine the opinion of parliament regarding that minister. That's it. And if you see that, it means that, to some extent, no matter what evidence the minister brings to defend himself, it doesn't matter. You can see that Parliament has already made up their mind. What is it that the minister is going to say that is going to change the minds of parliamentarians? What? They went from 80, they went to the president to remove him. That was 80 of them. Now it's 97. And we haven't asked him anything. So they have made up their mind. They see what is going on. They live in this country. We are in a ditch already. What else do you want to see? That's it. And so it's not a matter of guilt or innocence. No. It's not a matter that Parliament should give answers and evidence. No. Court of law, yes, evidence. But here, we are trying to find out how Parliament sees the minister, if they agree that it should be removed or not. That's it. And I say, the president has to do his job. If he doesn't, after the censure, if he doesn't You see, the Constitution, I'm sorry, is not properly written.
It's not properly.
If the president
is
not properly written in so many places. I've said it several times for a long time, 6 years now. Now we're beginning to see everywhere you look in the Constitution, there's a problem. So now we are heading towards almost like a constitutional crisis. The vote of censure, and he doesn't resign, and the president does not remove. What happens?
Yeah, I mean, Dr. Makuma, hold on for me. Martin Kpebu, do you agree that the way the Constitution has been crafted on this matter, and again, I'm looking at the end game, sets us up now for a constitutional crisis?
Evans, it becomes a crisis only if the president continues to be very intransigent, right? No. Otherwise, if he wants to use the spirit of the Constitution, which in Article 35, so you'll find probity, accountability, etc., transparency and all that, you find in countless Supreme Court decisions. So that's the spirit. When we say the spirit of our Constitution, probity, accountability, and all that, right? Transparency, correct? Great. Using those as the indicia for governance, you see that if this vote of censure passes, the president cannot be held to say it is still discretionary. No, for crying out loud, from the preamble of the Constitution to Article 35 and other articles, you see that it's clearly stated that sovereignty resides in the people. So the same Constitution, so you see that the may is trumped by other provisions of the Constitution. I've already mentioned the spirit, and then two, the express provisions, the sovereignty residing in the people, which we find in there and all that. So for me, now what we've learned, and I agree with Dr. Mwakuba, that the Constitution has a big problem. I think we all agree. So for the next government coming, and even assuming President Kufuor doesn't leave as we are calling on him to leave with Bawumia, and so we have to wait till 2024, I can see that constitutional review is going to take front and center of the elections. Yeah, it's going to be front and center. A candidate to be able to win massively will have to promise us a quick constitutional review. We've seen that this constitution is no longer fit for purpose. We have to redesign it, cut down the powers of the executive president, right? Make sure that parliamentarians will remain parliamentarians. They can't be that cross breed, so to speak. Ministers will be ministers. So we no longer want parliamentarians to be ministers at the same time. We've learned hard lessons from that, right? So you see that across the table, we all agree that this constitution is now such a big problem. It's an albatross on our neck, and we need to fix it, right? Great. So Evans, my point is that looking at these factors that I've raised, the spirit of the Constitution and the hard letter of the Constitution, that may cannot remain as may. And
yeah, but Martin, as we speak tonight, it is May.
Oh, Evans, remember the Auditor General case, Occupy Ghana versus Attorney General. The Supreme Court said the may in Article 187 about disallowance and surcharge is a shall. So that's why I'm saying that if the president is going to use the Constitution, that may you see there is a shall.
Okay, so what you're saying, and I'm only asking it because it's fair to assume that if you follow the president's approach and posture on Ken Ofori-Atta, when his own MP say won't do business with you, the entire parliament says he should go. We have the public opinions overwhelming, and he says I won't budge. It is very likely that at the end of the process, he will interpret the may and say it's may. And then eventually we'll have to resort to the Supreme Court. That definitely creates a core constitutional crisis at the time of an economic crisis.
Well, Evans, don't forget that there is always poetic justice. There is always poetic justice. You see, the time the president was calling the MP's bluff, did he know God was going to bring Anas to deliver this devastating blow? So the president better be warned. There is always poetic justice, and he can't do anything about that. I hope he's learned his lesson from the Edubuahin debacle, so he shouldn't try it again. That would be way too much. Otherwise, by the time the president will be leaving office, he will be so much derided. He would have totally eroded all his goodwill, eroded all his integrity, that it will not be funny.
Yeah.
It will be funny. So the president needs to remember poetic justice. poetic justice.
I have just a few minutes to wrap. I want to give two quick words to both Professor Bafo Jumendia on this very point we're just having about this potential constitutional crisis, how to anticipate it even at this moment, and resolve before we even get there. Prof?
Well, my hope is that we will not get there. What I expect to happen in the coming days or weeks is perhaps the finance minister taking himself out of this dilemma, or the president just announcing that he's displacing the finance minister, because it would just be tragic for these two individuals to lead the country into such a constitutional jam. We don't want that. We all know the difficulties we face, and in fact, what we are not even thinking about is the very negative impact of this crisis, or this stalemate, as you say, on our international partners and our financial relations with the outside world. Our market, somewhere else, our market will have plummeted further. So, in fact, we are doing ourselves a lot of ill if, in fact, the president and the finance minister, to use the word of my good friend Martin, continue to be intransigent on this matter, and not to appropriately respond to the groundswell of public demand for the displacement of the finance minister. I think we've come to a point where this matter should be resolved. It's not necessary to go through this whole process. And I do agree with Amakoba and the others that, look, this matter should have been settled right on the floor of Parliament. All this process of committees and I don't think it's necessary. We are prolonging something that is inevitable. So I think we have to find a way to end it.
Justice, a final word to you on this matter of the possible constitutional crisis. Do you see the constitutional crisis at the end of this?
Indeed, I do not see any at this moment, but I do see that if the president doesn't act swiftly, I would pray that the minority invoke the removal processes of the president, so that it becomes a lesson for all of us to see how the Constitution operates, so that we all can learn from in the future. Because I think that the blunder we find ourselves at this moment is because the Speaker didn't have the benefit of precedent to guide him in the kind of decision that he took. And so I would, for the purposes of posterity and indeed for learners and all other observers.
But this is the precedent now. This is the precedent we are setting. This is our precedent.
Yeah, but it's a wrong precedent. This is a wrong precedent that I'm sure, and indeed, wrong or right, I think we can all learn from it and do the most appropriate thing going forward. And it is indeed the same reason why that I would insist and call on the minority to invoke the removal processes of the president. That would rather require all the processes that they are going through, because in removing the president, you need to have arguments for the purposes of which you believe that on those bases the president should be removed. With a minister, you don't need reasons. The Constitution, in fact, the law doesn't even require you to offer reasons. You simply call, but simply because you need to convince the other side to join you on the vote. That is the only reason why you have to have reasons for the censorship to take place. Otherwise, you didn't need that. Us against the president, where the Constitution clearly provides that you ought to have your basis, because bases have been provided for the removal of the president. And I would wish to see that happen in my lifetime.
Yeah, well, thank you, gentlemen. We are all learning as this process rolls along. We make the rules as we go, we make mistakes as we go, and we learn. This is the beauty of our democracy. Friday, we get to see the finance minister mount his defense, and then we'll see how this pounds out when it goes to the floor. Very, very interesting, unprecedented times ahead. May Ghana be the ultimate winner. Enjoy the rest of the evening.